All right, I think we have our attendees mostly online with us. Thank you for joining Venable's monthly series of webinars on legal topics for nonprofit organizations. I'm Janice Ryan, co-chair of Venable's nonprofit organizations practice group, along with George Constantine. Today, we're thankful to be joined by our partners, Nawaday and Mary Gardner, for our session, When the Government Comes Knocking at Your Nonprofit's Door, How to Be Prepared and What to Do. I will briefly introduce Con and Mary, and then I will turn it over to them for today's session. Con Nawaday is co-chair of Venable's Investigations and White Collar Defense Practice. Formerly a federal prosecutor, Con defends corporate and individual clients facing criminal and civil actions. Mary is also a seasoned litigator with an extensive risk management and insurance practice, helping clients implement practices to minimize, monitor, and control risk. She represents clients in investigations and litigation by the FTC, DOJ, and state attorneys general, and in consumer class actions. So with that, I will allow Con and Mary to begin the presentation. Thank you so much.
Great. Thanks so much, Janice. So we're also thankful for you guys to join us today. And as Janice said, what we're going to go over today is how to be prepared and what to do when the government comes looking for information from your organization. And Mary's going to start us off with going through how to be prepared, how to get your data, document, policies in order, how to get your house in order so that when the government does come seeking information, you're best prepared to deal with it. And I'll go over, well, what happens when they do come looking for information from you. So Mary?
Thanks, Janice and Con, and thank you to all of you for joining us today. So as Con said, we're going to start with how do you get prepared? So we'll start by talking about document retention policies, best practices, and recommendations for implementing or revising your current document retention policy. First, let's start with the basics. What's a document retention policy? It's essentially a written set of guidelines for managing the documents, emails, and records that your organization maintains. And what it should do is it should help you track, store, save, and destroy documents. Make sure that all of those documents are kept for an appropriate period of time in compliance with both federal and state laws, as well as nonprofit best practices. And again, help you ensure that you're complying with applicable law. So why does your nonprofit need a document retention policy? First, the IRS is going to ask you about it. It'll be on your Form 990. It's a very good governance policy. And just as important, it has a dual cost saving mechanism. So if you're just keeping, you may just be asking yourself, well, why can't I just keep everything forever? Or why can't I just let my staff and personnel use their best discretion about what they should keep and what they should delete? You're going to spend a lot of money on document storage, both paper document storage and electronic, if you keep everything or if you let people decide what to keep, because most people are pack rats. I even have a pack rat tendency. So if you're not telling people what to delete and instituting an automatic deletion policy, you're going to have a lot of document storage costs. And then from Con's perspective, there's a lot of cost that goes into responding to government inquiries and investigations. If you've permitted your organization to keep everything from the beginning of time, Con will tell you that that is really going to exponentially increase the cost of collecting, reviewing, and producing documents in response to those requests. So it's important to think about this process as not just a good governance policy, but something that can really help you save money later on down the line. So from the outset, it's really important to note that there is no one-size-fits-all approach to document retention. you're going to, if you Google nonprofit document retention policy, you're going to see a lot of templates on the internet. You're going to see a lot of advice about documents to keep for 7 years, documents to keep for 3 years, documents to keep forever. That's a good place to start. Templates are a good place to start. Rules of thumb are a good place to start. But it's incredibly important that if you start with a template or you start with general guidance, that you still tailor your document retention policy to your organization's purpose, mission, types of documents, and also to your technological capacity as an organization and what your IT personnel thinks is appropriate. So there's that said, there are several components that you should consider when you're putting together or revising your document retention policy, starting with the who's. You need to identify who has to comply with the policy. Who at your organization, who outside of your organization has to comply. 2, you need to identify who at your company is going to be responsible for compliance with the document retention policy. That needs to be put in writing in the policy so that people know who to call. 3, and this is the obvious one, identifying the categories of documents and the retention/deletion time periods. In a lot of policies, that can be an appendix at the end. So, you have a lot of ways to think about that. This one's not as well known, but I think it's a best practice given today's increasingly remote work environment, including or referencing your communication and personal device protocols within your document retention policy. And I think particularly your personal device protocols, because your document retention policy should apply broadly to all records, even records that are maintained, all records of your organization, even those that are maintained on your employees' personal devices. So making sure that those two protocols align is just a good governance and management policy. Then, and I think you'd probably be surprised at how often I get surprised about this. Most people think about document retention and think, oh, it's about me having to save documents. A good document retention policy also sets forth automatic deletion protocols for all those categories of documents that you don't have to specifically retain for a period of time. It's just as important as including retained categories. And I'm not going to talk about it specifically, but Con is going to spend a good amount of time on it. Your document retention policy needs to discuss and address how the policy changes when a legal hold or a litigation hold is put in place. And essentially, how will automatic deletion and destruction policies be paused with respect to documents relevant to legal holds. And finally, a policy is only as good as the people who know how to use it. And so your policy should include a training mandate that you actually follow, and there should be an annual review period to think about how the policy is working and whether you need to propose any revisions to it. So let's dive into the initial steps your organization is going to want to undertake when you begin drafting or revising your document retention policy. So step 1, assemble the Avengers, assemble the parties that are going to be necessary to planning and implementing your policy. Now, it'd be great if I could tell you, you can assign this to someone in your in-house legal department and move on with your life. That these policies cannot be created in a vacuum by your in-house or outside legal counsel. Now, legal is a very important component of a document retention policy for a few reasons. One, federal, as we're going to talk about a little bit later, federal and state law will play a large role in certain retention periods. Legal is going to be a stakeholder with certain documents that have to be retained. And litigation holds play a very important role in this. But in addition to your legal counsel, IT personnel cannot be overlooked. You need to know what you're currently doing. Do you currently have an automatic deletion process in place? What systems does it apply to? And if you want to make changes, what changes are technologically feasible? Do you want to apply your document retention policy to Slack? You should. Is it possible to do so? Making sure that your tech people or document retention periods is a great. So you have an automatic deletion policy. It's currently set for 3 years. If you want to reduce that to 90 days, you need to make sure that your IT staff can do that before you put it in your protocol. And then finally, once you've talked to IT, once you've gotten legal counsel, you need to start identifying relevant company stakeholders to help you identify the types of documents that are important to be retained in each of your organization's large groups. And so, here, thinking about the finance department and the HR department, and if you have a group that oversees donors or volunteers, just making sure that you talk to those people and you understand the types of documents they maintain and create in the ordinary course of their business is very important to making sure that you are tailoring that policy to your organization's needs and mission. Then the next step is you're going to identify the parties that are subject to your document retention policy. I think this should always apply very broadly. It shouldn't just be staff. It shouldn't just be board members. You should look at applying this to your outside advisors. If you have volunteers, you should consider having it apply to your volunteers. And then step 3 in identifying the important parties is who's going to be responsible for training, implementation, and compliance. You need to identify someone who is willing and able to really do this job because it needs to be done accurately. And that includes being able to answer questions, providing training to people who are impacted and required to comply with the retention, auditing compliance, and overseeing the annual review of the policy. I know that sounds like a lot. It doesn't have to just be one person responsible for all of it. You can have different people responsible for different parts, but you need to know who those people are going to be because you need to involve them in the planning and implementation up front instead of just assigning them at the back end. So then, once you've identified the relevant stakeholders, it's time to start flagging the categories of documents that should be retained. Again, it's going to be specific to your organization, but you want to think about your accounting documents, your corporate documents, your legal and claims documents, board materials, government affairs and lobbying, real estate documents, HR. Think broadly, but also think creatively. These are your nonprofit organizations. What you're doing likely has some historical or archival significance as well. So think about the kind of documents that you would want your organization to still have in 100 years about something important that you were trying to do and accomplish. Make sure that you're thinking about your history when you're thinking about document retention. Once you've identified the relevant documents, then you have to start finding the relevant retention periods. And this is where it's very important to involve legal counsel because this is highly regulated at both the state and the federal level. So let's start with some examples of relevant state law. So most states have nonprofit regulations, and many of those states regulate the retention of certain documents that nonprofits create. So, for example, both DC and Virginia nonprofit statutes require that you maintain meeting minutes and records of actions taken by your board of directors permanently. So your document retention policy should reflect that policy. Similarly, when you're thinking about certain types of documents that can be the subject of legal claims, you need to know the relevant state statutes of limitations that are applicable to those kinds of claims. So, contracts. You should maintain a contract for the lifetime of the contract, plus any relevant statute of limitations for breach of contract. Similar for employee claims. If you have complaints of discrimination or retaliation, you need to make sure that you're maintaining those at least as long as the statute of limitations for that claim under state or federal law. Similarly, federal requirements, IRS, there's a requirement to keep certain records of your IRS filings for at least 3 years after your tax return due date. And then, as I mentioned earlier, one of the most important retention categories is actually your automatic deletion for all those documents that don't fall into a specifically retained category. So if you think about it, most of your organization's communications aren't going to fall within one of these specific retention categories. They're going to be short replies to emails to acknowledge receipt of something, or they're going to be emails trying to schedule a call or a Zoom. Those are likely not going to be retained. So it's important to establish a routine. I think doing it with your IT personnel so that it's something IT does automatically on the back end. Have a deletion protocol that applies to company email, documents, messaging apps like Slack, and to company cell phones to the extent that you have those. We see a lot of companies that are concerned about how short these deletion protocols can be. You don't want it to be so fast that that your employees don't have time to track and organize their emails that need to be retained, but you don't want it to be so long that you wind up in a position where you're keeping things for 4 or 5 years. So I think a good thought process about this is somewhere between 90 days to 1 year. But again, you have to talk to IT about what's technologically feasible across all of those platforms. But this will just really help your personnel comply with this policy. If what they're really worried about is tracking certain categories of documents like accounting, like year-end financial statements, copies of insurance policies, claims, check registers, then they don't have to worry about all the other stuff that goes away. Now, there are certain categories of documents that I strongly recommend you consider maintaining permanently, and they're listed on this slide. I'm not going to read all of them, but just to flag, articles of incorporation. I think that one makes a lot of sense. Looking at this, though, you may be thinking insurance policies. Why do I need to keep my insurance policies forever? Well, insurance policies, particularly those written on an occurrence basis, it doesn't matter when somebody files a claim against you. It matters when the injury or the damage happened in the first place. And so, I see in my insurance practice a lot of nonprofit organizations, particularly those that work with minors, getting claims for conduct that happened 20 years ago. And it is incredibly difficult and extremely expensive to try and recreate missing insurance policies. So it's just a good practice. So I want to transition and talk about personal device and communication policies for just a few minutes before I turn this over to Con to talk about what to do when things happen. Again, personal device and communication policies don't have to be a part of your document retention policies specifically, but you should reference them. We did get a question. Someone said email document retention between 90 days and 1 year is a big difference. Is there a best practice? I like closer to 90 days, but recently in talking to a lot of nonprofit organizations, tech people, they've pushed back on that and said that it's just not feasible. So the reason that I provide a larger recommendation of 90 days to 1 year is to give you some wiggle room to talk to your IT personnel about, again, what's technologically feasible. But I think the closer you can get to the 90 days is helpful, and that's just helpful from a number of perspectives. It also makes sure that your employees have a deadline for filing the documents and emails that they need to file, and that they're not waiting until the end of a year to go through an entire year's worth of email and file things. It kind of helps create an incentive for ongoing vigilance in the process. So again, turning back to personal device and communication policies, they don't have to be part of your document retention policy, but you should have them, particularly in today's remote environment. So first, starting with communication policies, particularly in a remote environment where we're doing so much of our communication via text messages, even if we shouldn't be, or instant messaging apps and communication tools, it can be really easy to forget the golden rule. I call it the New York Times discretion rule. If you don't want what you're putting in writing to be on the front page of the New York Times, you shouldn't put it in writing, and you should rethink the way that you're writing it. So I think that that's something to always remind people of. The other is talking about preferred methods of communication, what's appropriate for a face-to-face meeting versus a phone call versus an email or messaging, so that your people are communicating appropriately given the seriousness of a potential issue. And then just one thing about video meetings, we're recording this meeting. I think that's fine if you want as an organization to record meetings, but I think it's very important to not permit meeting participants to record video meetings. And that goes back to creating an unwieldy document retention issue. You don't want to be in a position where you're having to police individual recordings of video meetings for automatic deletion. Now, some important points to include in your written communications policy. It's always best to remind people to be professional in their communications. Very important to remind them that their business correspondence is owned by your organization, not by the individual. And that includes if they're using a personal device to do work business. That text message sent about work is owned by your organization. And Con can talk about it in more detail, but there are a lot of pain points if you have to collect and produce cell phone data. So reminding people up front in your policy that they don't own that data can be very important down the line if there is litigation that impacts that.
Mary, if I can ask a quick question on that, because I've heard folks and clients and employees say, well, the people I serve, my clients, your clients' clients, they text me. That's how they communicate. So what am I supposed to do? I mean, what's the best response to that kind of pushback?
I mean, I think it's a really valid point. And I think that what you should coach your employees on is they text you, you shouldn't engage in a substantive text conversation. You should ask them when is a good time to talk. And you should have a phone conversation or a meeting where you talk about the substantive issue. Not to bore everybody here, and Con could do it better than I can, but Con, correct me if I'm wrong. I believe if you have to collect cell phone data, most vendors will tell you they have to collect the whole cell phone. Right?
That can happen. It depends on what the actual app is. Sometimes they can do it over the air to the particular app, but ultimately they're going to dump everything from a particular app. Because the only way to really safely do a collection and review is to dump everything, run search terms, and search it. So that is another pain point, Mary, that you've been pointing out. You can tell employees, do you really want somebody coming in like Con and Mary looking through all your stuff?
Exactly. And somebody just asked a really good question about AI note-taking bots. I don't love them, but you're always going to have employees that use them. And so I think that that is a category of documents that you want reflected in your automatic deletion policy if people are going to use AI note-taking. But generally, you should discourage it, although there will be instances where it happens beyond your control. And yes, somebody also asked, should the document retention policy apply to your contractors and your consultants? Yes, to the extent that they're creating work product for your organization, that the retention policy applies to your organization's work product. So you can also seek to apply those policies to them. I don't want to take up too much more time. One of the really important points of your communications policy is prohibiting misleading, fraudulent, offensive, racist things from being said when someone is representing your organization. So not only do you want to flat out prohibit that kind of language, you want to include written consequences for the violation. And do that in coordination with an employment lawyer, but don't just have the consequences. Make sure that you're enforcing them. We've talked a little bit about Teams and Slack messages. I'm not going to spend a ton of time on this. I think that in today's day and age where these messaging applications are being used so much, your communications policies should include some practical guidance for how to use these apps in an effective and impactful way. So not just reminding people to not, have private conversations and personal chats, but to use threading, to use channels effectively. You want to make Con's job easier. Slack is incredibly expensive to collect, review, and produce. If you're using channels and if you're using threading, you're making that process in an investigation or litigation a little bit easier, and you're also giving your people good practices for how to keep Slack messages within the confines of what they should be. Finally, we talk a lot about remote work environments, and I know in a lot of nonprofits, you don't want to give people company cell phones. So a lot of nonprofits are transitioning to a model where their personnel are permitted to use personal devices to do organization businesses. You should include some kind of personal device policy as part of your document retention policy or standalone. And it should you should consider prohibiting some practices like use of a personal email address to conduct work, use of text messages to discuss substantive work issues. Again, clients are going to want to text you. It's about how you handle the response. You don't want employees storing work-related documents on their personal drives or desktops, and you want to, again, remember to enforce them. So what can you do to make sure that your employees' lives are easier when they're using personal devices? Give them phone applications that are linked to their work accounts, like BlackBerry Work or Teams or Slack app, and allow and have a remote login process for doing written work product. This is going to be very, very important. I didn't get into litigation holds much. Con's going to handle those and how they impact document retention policies. And with that, I'll turn it over to him to talk about what happens when you do get.
Great. Thanks, Mary. So number one, if it happens, what I tell people is don't panic. If you get a subpoena, you get an informal request from a government or a regulatory authority, there's no reason to panic. And on the next slide, we'll talk about the questions I like to ask and have clients ask on the next slide of how to figure out an answer to the question that you're going to be having if you do get some kind of law enforcement regulatory outreach. The questions you want to answer, I know this is the question that all clients want answered when they get something from the government. What is this about? And more importantly, is this about my organization? Now, how do you answer that question? You answer it by asking these other questions, because you can decipher from the answer to these other questions what it's about, and is it about your organization? The first one is who's asking, how are they asking, and what are they asking for? Now, on the next slide, we'll talk about who's asking. So who's asking is important to figure out, well, how serious is this and what is this about? Is this state or federal? Is it the state AG's office? Is it a DOJ component? Or is it another federal agency? Is it a local DA's office or local regulators? Second, you want to figure out, is this civil or criminal? Now, civil means it's about money. Criminal means it's about potentially someone going to jail. And third, you want to figure out, and you'll be able to see it from the subpoena or whoever is reaching out to you, the type of requesting agency. And that will give you insight into the subject matter of what the government is investigating. Pause here for a second. DOJ just doesn't do criminal investigations. They also do civil investigations. So even though you receive a phone call or a subpoena or something from DOJ, that doesn't necessarily mean that it's a criminal thing. It could also be a civil thing, like a False Claims Act investigation. That's a civil investigation that's done by DOJ, and it's also something that can be done by state AG's offices. Next, how are they asking? Now, I've set these different types of government process of how the government can reach out to you in increasing levels of stress, right? It can be an informal request. You can get a phone call from an agent asking for information. It can be a subpoena, more likely than not. For most of your organizations, for an organization, it's going to be a subpoena. It can either be an administrative subpoena or civil investigative demand. Those are essentially the same. An administrative subpoena is essentially a subpoena that a regulatory agency has, by statute, the power to issue in order to gather information that they are statutorily authorized to do to investigate. Civil investigative demand is similar. You can get from a DOJ component a civil investigative demand when they're investigating a False Claims Act case. Next up, and by the way, administrative subpoenas, civil investigative demands are civil cases. Next, a grand jury subpoena. Grand jury subpoena, I think most people know, that means it's a criminal investigation. So if you get a grand jury subpoena, of course, it's a lot more serious, and you really want to figure out what's it about. Is it about your organization? And the most serious government process is a search warrant. That's when law enforcement arrives. And by the way, search warrant is only for criminal investigations. That's when law enforcement agents just show up at your door with a warrant to look for and take materials from you. Key difference, which is fairly obvious between an informal request and a subpoena, a grand jury subpoena, and a search warrant is, with the first three, the government's saying, this is stuff we want. We're going to rely on you to go look for it and give it to us. Search warrant means that they are coming to take it from you. They're not going to rely on you to go look for stuff that they want. So on the next slide, what are they asking for? 9 times out of 10, 10 times out of 10, they're looking for documents. Okay? They're not looking for testimony. Testimony means that they want to talk to people. They want someone to speak with them. That is very different. 9 times out of 10, really 10 times out of 10, they're just going to want documents. And typically, the subpoena will set forth certain statutes that will give you hints of what they are looking for. For instance, if you get an S subpoena, they're looking for healthcare type information. If you get a subpoena from DHS ICE, they may be doing an audit of your I-9 compliance. So again, what they are asking for will give you insight on what the actual government investigation is about. So one of the first things you should do on the next slide to figure out what's going on is, of course, send it to your counsel. They will review the subpoena carefully, figure out your obligations. Another reason to send it to counsel is you want a buffer. You want counsel to be interacting with the government agency, as well as giving you advice in a privileged environment of what this is about. Another one of the first things you should do is also make sure that the subpoena is properly addressed to your organization. Of course, there can be legal consequences for sharing information of third parties and the people you service with someone else like the government. So you want to make sure that you have coverage and that when you do provide information to the government with all your stakeholders. So to go back to something I said earlier, you may get a phone call from an agent saying, hey, can I get information for XYZ? And it's an informal request. And what I advise clients is be cooperative. But typically, if you're in an organization, I'd say ask them for a subpoena, because that will give you coverage if the information you're providing implicates other contractual and privacy obligations you may have. And these next bullets, pretty simple. One, make sure you understand the information being requested. Also, confirm that the subpoena allows for disclosure of the subpoena. What do I mean by that? Sometimes you will get a subpoena or a grand jury subpoena where the cover letter says, please keep this, the fact of the subpoena confidential. Now, I will say this, no government agency can force you to do that. You could tell anybody you want, hey, I got this subpoena. But my advice is always don't do that. What you want to do is, to the extent you need to disclose the subpoena to someone else, you tell the government first. And the point to do that is you never really want to get crosswise with the government, because the last thing you want to do, one thing that you can get you into trouble and crosswise with the government, is if they think you're doing something to obstruct their investigation. Last thing is check the response date. And I will tell you this, whatever the due date is on that subpoena or request, it's going to be something that you cannot meet. Because what they do, almost every piece of government process, I've done it when I was a prosecutor, it automatically defaults to, please provide this in 2 weeks. No one's expecting you to provide things in 2 weeks. What they are expecting is a phone call, conversation, and discussion about how long it's going to take you. So please, for 10 times out of 10, if there's a response date that is 2 weeks, it's very short, you're not going to be able to do it, don't stress out about it. It's not, I tell people, that's not a real date. We're going to talk to the people who are asking. We'll figure it out. Next slide.
Con, do you mind if I interrupt you and give the
Of course.
CLE
Please.
code? For those of you waiting, the CLE code is DOOR 2025, DOOR 2025.
Okay. So you sent it to your lawyers. What are your lawyers going to do? Well, first off, they're just going to call the agent, the prosecutors, the government lawyers, the regulators who've asked for this stuff. And one thing that they should be asking is this organization that you subpoenaed a target, subject, or witness? And those are terms of art, and they're self-explanatory. If you're a target, that means they are looking at you. If you're a subject, that means they don't know either way. And if you're a witness, this investigation doesn't have to do with you at all. And they just believe you have materials and information that will be helpful to them to further their investigation. So the second thing you and your lawyers will want to do is limit the scope of the subpoena. Subpoenas drafted by regulators and law enforcement, they always end up being too broad because they don't know exactly what they're looking for. They don't know what records you have. So almost always, there'll be opportunities to limit the scope. You want a reasonable basis to limit the scope of the subpoena, and it could be, listen, you've asked for basically all our documents. We can't do that. What do you really want? So those kinds of conversations are perfectly reasonable. Regulators, the government, the people asking for these materials, they understand that there will be a back and forth. These next bullets, go back to what I said earlier. You're going to request an extension, a reasonable amount of time to get the materials together. Also, one thing counsel and you will have to also determine is whether third-party obligations and rights are impacted by producing these materials, and whether you need to raise them with the agency that's asking for these materials. What do I mean by that? Invariably, you may have materials that are subject to an NDA or subject to some contractual obligation where by providing these materials to the government, it may impact your obligations. So you want to be mindful and be ready to vet that depending on the types of information the government's asking for. The last bullet, determine whether an internal investigation is necessary. What do I mean by that? Well, if you're a witness and your counsel has advised you, listen, there's no exposure, civil or criminal, for your organization. This investigation isn't about you. Then you don't need to do an investigation. But if you're a target or subject, such that you believe that the government is investigating your organization's own conduct, then what you'd want to do is have counsel conduct its own investigation in parallel with producing documents to the government. The reason for that is to find out, well, what happened? What are they investigating? So you can get ahead, and your organization can get ahead of what's coming down the pipe. It's the next slide. Now, what do you actually do? What's the day-to-day? You got the subpoena. All right, well, one, figure out if you actually have this stuff. And sometimes you get a subpoena and it's an easy answer. We don't have it. And how are you going to do that? You're going to identify the employees who may have responsive materials. And what Mary's been talking about, you're going to send a litigation hold. So once you've identified the folks who reasonably may have materials responsive to what the subpoena is calling for, it's to those folks you send the hold. And you also get IT on the phone immediately to figure out how to shut off automatic deletion and ensure that the materials that are potentially responsive to the subpoena are preserved. And this goes back to making sure that your organization isn't seen as somehow obstructing a government investigation. You want to make sure that there's no issue with you having not taken the steps that you needed to take to preserve information that the government wanted. So again, IT is your friend in this day and age. So you really, as Mary said, you want to have a plan. You want to know the folks you need to call once you get a subpoena or outreach from the government. And IT should be able to tell you, these are the folks, we'll do this. This is where they keep their stuff, and you'll have an understanding of where materials are, so that counsel can go in with the help of typically a vendor or your IT group of collecting those materials and beginning that review to start producing materials to the government. So to identify folks and custodians who may have relevant materials, I always tell people, work from the top down. You talk to higher level employees, supervisors who may know the subject matter of the materials that are being sought, and they'll know, okay, who has stuff. What counsel will do, I typically recommend having counsel do it to take the client, you, out of the loop, to make sure that there is that privilege protection. Is short interviews with potential custodians to find out in those interviews, do you have stuff related to what's being asked for, and where is it? Because you want to make sure someone may tell you, oh, I actually save things locally on a local file. Someone may not follow Mary's Good policy that's out there. So you're going to need to have those one-on-one conversations to make sure that you're not missing anything. Because one of the last things you want is providing all these materials to a regulator or government authority, and then later on they realize, wait a second, John Doe had all this stuff on their personal phone that's relevant to our investigation. Why didn't you get this? Why didn't you provide this to us? And I put in red at the very bottom, please don't forget about off-channel communications. Those text messages that unfortunately people may have where they're conducting your organization's business on channels, on applications that aren't sanctioned by your organization, and where you don't necessarily have insight that those communications are happening. And by the way, the government fully expects that a question that's been asked of me multiple times when I've done investigations and responded to government inquiries. Prosecutors always ask, have you asked these custodians about materials on their personal devices? That is an expectation from the government. They expect that you all are doing that. Next.
Ron, I have a question about you mentioned down here some encrypted apps and use and collection of encrypted apps. Is the government really going to expect that you collect and produce information from encrypted sources?
That you ask about it, yes. And that to the extent you're able to, the government understands that some of these materials may not be available, right? But you have to ask and you have to try. So in matters involving DOJ, I've pulled and reviewed Telegram, Signal. So it does happen. And it is expected, depending on, again, this goes back to which government agency, right? But a lot of federal government agencies, depending on the nature of the investigation, would expect that. And this goes back to, there was a great question from someone out in the audience about, how about third parties and contractors? And because some of y'all may use vendors to store your data. And unfortunately, because you control these documents that a vendor may actually have possession of, you are actually obligated to search those materials to the extent it's reasonable and necessary to respond to the subpoena. So you do have to alert third parties, potentially call up your vendors who may be storing your materials to stop auto deletion and to assist you in collecting documents responsive to a government request. So next steps, once you've identified where is this stuff, then it's a matter of collecting those materials, running search terms across them based on what's being asked in the subpoena, having it be reviewed, typically by counsel, and then providing it to the government. The whole point of doing a production and collecting things in this very meticulous manner is you want a defensible production of materials to the government. So that, and typically your counsel will be in conversation with the government to make sure that the government knows, the regulators know, whoever's asking, that every step you're taking or the steps you're taking, so there's an understanding and there's transparency about what you're doing, where you're looking, and that you get buy-in from the folks who are receiving this material from you. So and this is what I just spoke about, you want to make sure that you have a defensible collection review. And that goes back to Mary's point of having that policy in place before any of this happens so that you have a plan in place and a defensible plan that's principled and reasonable about how you maintain data and how you produce it. Next slide. Oh, sorry. I think we want to go forward. And so if the request, depending on the request, hopefully for all y'all who are out there, the request is going to be fairly simple. It's going to be narrow. You make one production. Maybe it's just a request about a particular individuals who you service or serve or something like that, and it's very narrow. There could be situations, and these situations happen typically when your organization is a subject or target, where it's just so much information that you have to do rolling productions, and the government is very used to not getting everything at once. All they want is a steady pace. They want communication about how long it's going to take you, why it's going to take you so long. And they also may have additional requests. And if they do have additional requests, through your counsel, you can decide whether you're going to provide materials based on those additional requests without a subpoena because you're in a cooperative posture, or if you're going to request an additional subpoena to cover those additional requests. Next slide. All right, so I've moved quickly. I'm going to pause for a second. Search warrant is decidedly different from a subpoena. I think folks know that. So I'm just going to go over the basics and what it is and what you should do if it ever you ever have the unfortunate circumstance of getting served a search warrant. First off, I will say that most law enforcement agencies, I would say most federal law enforcement agencies, for organizations, when they need information from organizations, they go the subpoena route because they know how disruptive a subpoena is. Plus, there are more approvals necessary at the law enforcement agency to execute a search warrant on a business or organization. And plus, judges will scrutinize a subpoena, a search warrant on a business or an organization. So, for instance, grand jury subpoena. How does that happen? Who needs to approve it? Typically, there's no judge involved with approving a grand jury subpoena. At the U.S. Attorney's Office, we had a drawer of grand jury subpoenas. If we had a reasonable basis to believe that information from a particular company was necessary for our investigation, we print out a subpoena and send it, as long as there was a case and investigation open. And search warrant is decidedly different because it's so intrusive. So number one, it is judge ordered. So what happens is the law enforcement agent with the prosecutor has to go before a judge and have an affidavit of the agent setting forth the reasons why this that a crime has been committed and that the search of a specific place to seize evidence of that crime is warranted. So the standard is called probable cause, and a judge will review that affidavit from an agent to determine whether there's probable cause to search a specific place and that there's to seize evidence of a specified crime, and that evidence of that crime will be found at that specific place. What is probable cause? Well, I think you all know what beyond a reasonable doubt is. That's what's necessary to convict somebody of a crime. And that's way more than 50%. There's preponderance, which is more likely than not. So a little more than 50%. Probable cause is much lower than more likely than not. What it is whether a reasonable person would believe that the search of a specific place would lead to evidence of a specific crime. So it's a reasonableness standard, and it's fairly low, but it is reviewed by a judge. So what can you do pre-warrant? One, like with the document retention, please have a plan. At the very least, ensure that employees who would be potentially interacting with agents when they show up at your doorstep have contact information of counsel. The day of the warrant, you want to obtain that contact information of the lead agent. They will come, there will be a bunch of agents. Then you want to contact counsel, put counsel on the phone with the lead agent. If counsel can't get to the premises immediately, keep her on the phone to tell her what's taking place. You want to get a copy of the warrant to counsel. And by the way, the warrant is going to set forth areas to be searched and what they, the law enforcement agents, are allowed to search for. You want to read that warrant carefully to make sure that they're only searching areas listed on the warrant and they're only taking materials that are listed on the warrant. Until your lawyer arrives, designate an employee to document without interfering, because you don't want to obstruct what they're doing. If they have a warrant, you have to let them take what they are allowed to take. But you do want to document what they're doing so that you can debrief counsel later. Typically, when law enforcement issues executes a search warrant on a business, they're going to look to talk to employees. You should tell your employees that they understand, make sure they understand interviews are voluntary. On that note, I'd also send employees home. I tell the agents first, I'm sending my folks home so that, this because of what's happening. And I'd also call employees who haven't even arrived, don't come in. Something that folks don't, a question that comes to mind often in these types of cases, in situations is, well, do I have to provide the materials, right? On a subpoena, do I have to give people things? Do I have to give the government things? And if they're reasonable things, you do, because companies and organizations don't have a Fifth Amendment right. But you do have a Fourth Amendment right to unreasonable searches and seizures. So on that note, I'll end.
And we had an interesting question from the audience asking if you have any guidance for nonprofits on what they can tell their office staff about interacting with law enforcement in that first communication.
Oh, can you say that again, Mary?
So the question, what should nonprofits tell their front of house office staff about engaging with law enforcement if they do call the front desk or knock on the door? What should they tell them about how to communicate with them?
Oh, be cooperative, ask name, where are they from, and tell them that in-house counsel or someone from the counsel's office is going to get back to you very soon. Thank you. That's what I would do. And I think there was a question about whether you need to go to outside counsel or in-house counsel. I mean, in-house counsel can do it. Those initial interactions, absolutely. But so for the folks, the employees, it's get name, number, and tell them someone's going to get back to you very soon from in-house counsel's office. Thank you. And ask them for, if it is a subpoena, can I get the subpoena? Thank you.
And then I hate to go over, but somebody asked a really interesting question about search warrants on fully remote office spaces. What do those look like? Are they possible?
So here, I think it'd be difficult for the government to kind of figure, if you're talking fully remote, where all your employees are remote, there's going to be no physical space, right? So they'd have to figure out, it'd be hard for them to get, I think, probable cause that a particular employee has materials. I think what they would do is they would find out who your vendor is, like where your servers are, and they could issue a search warrant on your vendor. For instance, like law enforcement can't get someone's Gmail without a search warrant. Like if my Gmail, they would need actually a court-ordered search warrant to get my Gmail. So something similar, I'd imagine, for those remote businesses. What they would do is they would get a search warrant on your service provider, Amazon, like AWS, something like that. And then when that happens, you might not find out that it's happened.
Hmm.
I mean, in all likelihood, you won't find out, actually.
Thank you so much, Con and Mary. There's so much here. There are so many great questions. If folks have additional questions, please reach out to us. Let's give you the CLE code once more before we leave. It's DOOR 2025, DOOR 2025. We thank you all for joining us, and we hope you have a good rest of your day.